Hello, this is Grant Hughes of Grant Hughes Investigates on YouTube. Please hit that like button, share, and subscribe. Today's video is regarding the Idaho 4 murder case of Madison Mogan, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle. And this happened on November 13th, 2022. Bryan Kohberger has been arrested, and I believe they got the right guy. I am 100% Bryan Kohberger is the killer, as he left DNA on a knife sheath that was deposited at the 1122 King Road residence that we see right here in a 12-minute window, while a white Elantra missing its front license plate was parked right outside, and that's exactly the type of vehicle that Bryan Kohberger drives. And even recently, his attorney admitted that he was within a quarter mile of the residence at 3:29 in the morning, and as we know, the vehicle, the white Elantra, did multiple loops passing back behind the residence, finally stopping around 4:08 and leaving at a high rate of speed at 4:20. So today's video is regarding the alibi that Kohberger put forth, but there's a recent document where the prosecution appears to be trying to get any alibi information thrown out and only allow it in if Kohberger himself testifies. So let's take a look at the new filings here. This is what the prosecution has just put out, a motion in limine regarding alibi. Comes now the state of Idaho by and through the Latah County prosecuting attorney, and respectfully moves the court in limine for an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from defendant himself. And the reason they're doing this is because they've given Kohberger many opportunities to provide an alibi, but what the defense team is trying to do is figure out what cell phone data, etc., that the prosecution has and where their theory is going, so they can tailor an alibi from Bryan Kohberger to match that. But the prosecution does not want to allow Kohberger to do that. So the background of this is laid out right here in the document, and so what we'll do is we'll go to each one of these things and sort of go back in time and put together the order of the back and forth regarding the alibi demand. So by way of background, the state refers the court to the following: the state's May 23rd, 2023 request for discovery disclosure alibi demand. And let's go to that. It's right here. And it goes through all these different things that they're demanding. But right at the bottom, it says, further, the state hereby demands of the defendant notice of defense of alibi pursuant to Idaho Code 19519 and Idaho Criminal Rule 12.1. So there it is in this document. It's asking for that at the bottom in bold text. Now the defense actually responded, notice of defendant's response. They said, comes now Bryan Kohberger by and through his attorney of record, Ann C. Taylor, public defender, and hereby files notice in response to the demand for alibi in compliance with Idaho Code 19519. Mr. Kohberger notes that Idaho Code 19519 preserves his constitutional right to silence as well as to testify on his own behalf. Mr. Kohberger stands firm on his constitutional right as well as the statutory recognition of that right. Noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. A defendant's denial of the charges against him does not constitute an alibi, but as soon as he offers evidence that he was at some place other than where the crime in which he is charged was committed, he is raising the alibi defense. Mr. Kohberger's defense team continues investigating and preparing this case. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules. See, what they're waiting for is information to come in so they can tailor what they want to say. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state as well as calling expert witnesses. All right, now let's go back to this document. And here it says the state's motion to compel notice defense of alibi or alternatively to bar certain evidence. And that's what we get right here. Motion to compel notice of defense of alibi or alternatively to bar certain evidence. This is by the state again. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for an order compelling the defense to comply in full with Idaho Code 19519 and ICR 12.1 and provides the state with notice of an alibi that may be offered herein, said notice to include the specific place or places at which the defendant claims to have been at the time of the burglary and homicides in this case, and the names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi. Now it says the word "and" in there, And, if he's just driving around like he claims, I don't know if he's going to have a witness that's going to be able to corroborate that. But, it's interesting that the defense wants to rely on cell phone data, but Kohberger's phone was off during the commission of the crime, so how are they going to know exactly where he was at that time? As the court file reflects, the state filed its request for discovery disclosure alibi demand on May 23, 2023, and served the defense on that same day. The parties subsequently stipulated to extend the statutory time for a defendant to provide notice of alibi and comply with Idaho Code 19519 ICR 12.1 to July 24th. And then on July 24th, 2023, the defendant filed notice of defendant's response to state's alibi demand. This document does not comply with the requirements of Idaho Code 19519, and we just read the July 24th document. So this document does not comply with the requirements of Idaho Code 19519 and ICR 12.1 in that it does not specify a place or places in which the defendant claims to have been at the time of the offense herein, nor does it provide names and addresses of witnesses upon whom the defendant intends to rely. The state recognizes that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. However, as noted in both of these cited cases, the defendant's rights to call witnesses in his or her defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery response from the defendant, and that's Juarez Supra. As the Juarez court also observed, requested by the state during discovery, a defendant intending to offer an alibi must file notice where the defendant claims to have been at all time of the alleged offense and the names and addresses of witnesses whom testimony will support the defendant's alibi. As evidenced by the defendant's July 24, 2023 notice of defense response to state alibi demand, the defendant has failed to comply in any fashion with the requirements of the statute, court rule, and applicable case law. It is important to note that the scheduled October 2, 2023 jury trial is barely more than 2 months away. Obviously, we know it was moved almost a year after that. If the defense intends to rely on alibi, it is essential that they be required to provide prompt notice to the state so that they can fulfill its obligation under Idaho Code 19519 to investigate and respond to the notice of alibi. Any further delays will substantially prejudice the state's rights, similar to the situation in Juarez. The state has no idea how the defendant's notice regarding alibi constitutes an alibi, and as observed above, the state is unable to comply with ICR 12.1 and Idaho Code 19519 because based on the lack of information in the case, we don't know how this is an alibi at all. The state also notes, as the United States Supreme Court observed in Taylor v. Illinois, the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. The adversary system of trial is hardly an end in itself. It is not yet a poker game, which players enjoy an absolute right always to conceal their cards until they're played. Based on the above, the state respectfully praise the court for an order compelling the defendant to comply in full with Idaho Code 19519 by filing a notice specifying where the defendant claims to have been at the time of the alleged offenses and the names and addresses of witnesses whom testimony will support the defendant's alibi. Given the time constraints, the state prays that the courts direct the defendant to comply no later than 10 days from the date of the court's order and that the state be allowed, pursuant to Idaho Code 19519, to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses, and any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses no less than 10 days before trial. Alternatively, the state prays for an order of this court pursuant to Idaho Code 19519 prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from defendant himself. All right, so now let's go back up to here. The defendant's August 2nd, 2023 objection to the state motion to compel, and that is right here. Comes now Bryan Kohberger, by and through his attorney of record, Ann C. Taylor, public defender, and hereby and objects to the state's motion to compel, motive of defense of alibi, or alternatively to bar certain evidence. Idaho Code 19519 require an alibi disclosure of a specific location with a specific location and witnesses to so testify. By statutory definition, Mr. Kohberger may remain silent, yet testify that he was not at 1122 King Road, November 13th, 2022. However, In an abundance of caution and recognition the court has authority to exclude witnesses, Mr. Kohberger has indicated he anticipates corroborating witnesses. Wow, that's amazing. Let's just go down here. Mr. Kohberger has long had a habit of going for drives alone. I mean, listen to how ridiculous this is. Often, he would go for drives at night. He did so late on November 12th and into November 13th, 2022. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night November 13th, 2022 and early morning November 13th, 2022. He was out driving during the late night and early morning hours on November 12th through the 13th, 2022. Counsel for Mr. Kohberger is aware the case law broadens the definition of alibi with the statutory requirements of a specific location to more broadly include disclosure of information that tends to state the person claiming alibi was at a place other than the location of an offense. Mr. Kohberger has complied to the extent possible at this time. Corroboration of Mr. Kohberger not being at 1122 King Road may be brought out through cross-examination of the state witnesses. At this time, Mr. Kohberger cannot be more specific about the possible witnesses and exactly what they will say. The defense has been hampered by the state's own choices. The state chose a secret grand jury rather than the planned preliminary hearing. Had the state moved forward with the preliminary hearing, the defense would have had the opportunity to develop testimony through cross-examination and witness presentation. Right, so you're trying to, again, tailor your alibi to the information that the prosecution has. Instead, the defense has only received on July 27th a copy of the testimony the state chose to elicit. Review of such is underway. The defense had to obtain investigative materials from the state investigative counterparts, the FBI, through an order compelling the state to provide much materials. The state made draft disclosures just 2 weeks ago. So here, I mean, basically this document here is just Ann Taylor whining and crying about, not getting certain information because they need to use it to be able to tailor their alibi. All right. So now let's go back to the motion recently filed. So we just went over these three. The attached partial transcript of the August 18, 2023 court hearing relating to alibi, where the then presiding Judge John C. Judge observed that the defendant's proffered so-called alibi, not really an alibi, and that he will address the issue of the alibi disclosure in a subsequent scheduling order beginning at line 8. Okay, thank you. Well, the way I understand this is that this is the so-called alibi, not really an alibi, but, quote, he was out driving during the late night and early morning hours of November 12th to 13th, 2022. So what I'm going to do, because the next motion is for scheduling order, I'm going to address this in terms of deadline, and we'll see how that goes. Right now, that is as far as Mr. Kohberger wants to go with regard to alibi, and that's fine. But if there's going to be, and Ms. Taylor, you suggested that there might be some witnesses, then you need to cough them up by a certain date, certainly before the trial. I have read the Albert case, which was interesting because there were late witnesses. The judge refused to allow them to testify, and that case was overturned by Supreme Court, or not the Idaho Supreme Court. Maybe it was the Court of Appeals. I don't know. I'm looking at that. But then Perez, that was 2021. That was a Court of Appeals, and they said, out of luck if you're too late. And so I think, Ms. Taylor, you acknowledge that potential risk to your client in your latest response to the request. So there is some potential balance there. And certainly, Mr. Kohberger doesn't have to say a word, and that is protected by the Constitution of the United States and Idaho. The August 22nd, 2023 scheduling order, which in paragraph 7 at page 2 addresses the deadline for the defense to comply with statutory obligations for alibi disclosure. This scheduling order was subsequently vacated when the defendant waived speedy trial on August 23rd, 2023. All right, so let's go to that one. And here is that section right here. This is chapter 7, page 2. Defendant intends to rely on the defense of alibi, a notice of alibi, with the specific place or places defendant was at the time of the alleged offenses and the names and addresses of the witnesses defendant intends to rely on to establish such alibi is due by September 8th, 2023. All right, so you have that. And now let's go back to the original document. So that was in this section right here. But now we're on number 6. The state's December 21st, 2023 motion for scheduling order And it says on page 3, full paragraph, in its August 22nd scheduling order, the court ordered the defendant an additional opportunity to provide notice of alibi in accordance with court rule and statute. The state submits that the defendant has already been offered this opportunity, and the court heard arguments on the motions relating to such. The state submits the opportunity for the defendant to disclose an alibi and notify the state of the same has passed, and asks that the court not reopen this issue. All right, and then we move on to the February 23rd, 2024 order setting deadline and hearing, which in paragraph 1 sets an alibi compliance deadline of April 17th, 2024. Any notice of defense of alibi must be filed no later than April 17th, 2024 if defendant intends to offer a defense of alibi. The notice must comply with Idaho Code Section 19519 and shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of witnesses upon whom he intends to rely to establish such alibi. Now, the prosecution is like a broken record here because the defense is not complying with the demand and not even complying with the judge's orders. It's ludicrous. I mean, it's absolutely insane. The defendant's April 17, 2024 notice of defendant's supplemental response to state's alibi demand. And here we go with that. Right here. Comes now Bryan Kohberger, by and through the attorney of record Ann C. Taylor, public defender, and hereby files a supplemental response to the demand for alibi in compliance with Idaho Code 19519 and Idaho Criminal Rule 12.1. Mr. Kohberger, I mean, this is almost laughable here. I'd play the clown music, but you might not be able to hear what I was saying. Mr. Kohberger moved to Pullman, Washington in June of 2022. As an avid runner and fly fisherman, I'm sorry, it doesn't say fly fisherman, and hiker, he explored many areas of the Palouse. Of note, he explored Wawawe Park in July of 2022. And this became a favorite location of his. After the school year began, Mr. Kohberger was busy with classes and work at Washington State University, and his running and hiking decreased. But it did not stop. Instead, his nighttime drives increased. This is supported by data from Mr. Kohberger's phone, showing him in the countryside late at night and into the early morning on several occasions. I wouldn't doubt it, as he was practicing and planning and mapping out his routes that he was going to be using. The phone data includes numerous photographs taken on several different late night evenings and early mornings, including in November, depicting the night sky. You know, this is where we should probably play Rocket Man, you know. Mr. Kohberger was out driving in the early morning hours of November 13th, 2022, as he often did, to hike and run and or to see the moon and stars. I packed my bags last night, pre-flight. He drove throughout the area south of Pullman, Washington, west of Moscow, Idaho, including Wawawe Park. Wow, that's amazing. Mr. Kohberger intends to offer testimony of Cy Ray, CSLI expert, cell tower, cell phone, and other radio frequency curricula vitae is attached, to show that Bryan Kohberger his mobile device, was south of Pullman, Washington, and west of Moscow, Idaho, on November 13, 2022. That Bryan Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on video along Moscow-Pullman highway near Floyd's cannabis shop. Additional information as to Mr. Kohberger's whereabouts as the early morning hours progress, including additional analysis by Mr. Ray, will be provided once the state provides discovery requests, and now subject to an upcoming motion to compel. Again, they're waiting to see what the data says so they can tailor Kohberger's alibi to match that. But as we know, Kohberger says he went to Wawawe Park, which is, I believe, right over here. Okay, yeah, there it is, Wawawe Park. And they're trying to make it seem like that because on that route that he drove back, if I turn back on all of the objects that I have on the screen regarding this case, I mean, it's huge. This green line right here is the route that law enforcement put down and sort of visualized how he came back based on cell tower pinging. They say he was over here and that he was never over here. But the truth is Kohberger's phone was off, and then at 4:20, the Elantra sped away at a high rate of speed and made its way down in this direction. And then right near Blaine, Idaho, the cell phone pinged at 4:48. So that's when it was turned on. So it is south of Moscow, Idaho. And then they were able to track it as it made its way around. And that's where the defense picks up. And they only say it was over here and over there. and eventually comes home, but the timing is impossible. It's impossible for his phone to have pinged at 4:48 over here, and then for him to go to Wawawe Park, way over here, and then make it back over here where his phone pinged at around 5:25-ish in Pullman, Washington. It's impossible. So that's why they're now trying to shift it up again, because they realize what they gave in this document was completely bogus. All right. So let's get back to this. The state's April 26, 2024 response to that very same notice regarding Wawawe Park and a supplemental response to state alibi demand. And here is that. Comes now the state of Idaho by and through Latah County prosecuting attorney and submits the following initial response to the notice of defendant's supplemental response to state's alibi demand filed herein on April 17, 2024. At the outset, the state incorporates by reference, as it fully set forth at this point, those portions of the state's July 27, 2023 motion to compel notice of defense of alibi, or alternatively to bar certain evidence to the extent that it relates to adequacy and timeliness of defendant's alibi notice. The state specifically submits that the defendant's supplemental alibi response continues to lack the specificity required by Idaho Code 19519, which provides that the defense shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. The defendant's April 17, 2024 submission minimally adds to the alibi notice dated July 24, 2023. The defendant states that he was driving around during the early morning hours of November 13, 2022, and drove throughout the area of south of Pullman, Washington, west of Moscow, Idaho, including Wawawe Park. With the exception of the reference to Wawawe Park, which is new, the defendant is offering nothing new to its initial alibi, that he was simply driving around during the morning hours of November 13, 2022. As the state noted during the August 2023 hearing, the state is aware that the defendant was driving around rural areas of Whitman County, Washington, and Latah County, Idaho during the early morning hours of November 13, 2022. In fact, the defendant's travels during that time are described in the original probable cause affidavit supporting the criminal complaint in this case. And that green line right here is in the probable cause affidavit. See how it drives all the way down here and then back up? And by the way, I drove this route here, and you get here exactly when you're supposed to be there. I mean, it's amazing. The timing is perfect. And I actually think he turned his phone back on here to look at his maps, because this area here is crazy. I mean, I had to stop, turn around a couple times, and finally was able to make my way through. But this is how they have it in the probable cause document, this green line there. As to the defendant's reference to potential testimony about the location of the defendant's cell phone on the morning of November 13, 2022, this information does not rise to the level of an alibi at the time of the homicides, because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. The location of defendant's cell phone at times other than the time of the homicides is not proof of or relevant to the defendant's specific location at the time of the homicides, approximately 4 to 4:30 a.m. I would actually say from 4:08 until 4:48, a 40-minute window. That's what I would put. It is the state's position that the defendant continued failure to adequately comply with Idaho Code 19519 does not trigger a response under Idaho Code 19519 if the court deems the defendant's supplemental response to be in compliance with the requirements of Idaho Code 19519. Yeah, so let's just move it down here. It is approximately 11 months since the state filed the request for discovery disclosure alibi demand on May 23, 2023, and almost a year and a half since the homicides occurred. The defendant has been given more time than he is legally entitled in order to provide his alibi. The state is substantially prejudiced and compromised in its ability to investigate and respond to new or additional alibi-related disclosures. As the Idaho Court of Appeals noted in State v. Juarez, the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. The state respectfully submits that we essentially remain in the same position as in July and August of 2023, and that, like Juarez, we don't know how this is an alibi at all. As the state's further noticed in its July 27, 2023 motion to compel notice of defense alibi, or alternatively to bar certain evidence, the United States Supreme Court has observed in Taylor v. Illinois the case with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. Based on the above, the state respectfully requests that the court enter an order denying the defendant any further opportunity to add any purported claim of an alibi and preclude testimony by anyone other than the defendant as to the defendant's absence from a presence at the scene of the homicide. All right, so this is back in April 26, 2024, and they've still been waiting, and they still don't have an answer from these clowns. All right, so that was the state's April 26, 2024 response to notice of defendant's supplemental response. Former presiding judge, John C. Judge, June 27, 2024 scheduling order, which is subsequent to the April 17, 2024 alibi disclosure deadline, and which makes no further reference to alibi. So basically what they're saying is, the prosecution is saying is, this is the judge's scheduling order for the trial, when it was going to be in June, that alibi isn't even mentioned in here because the defense failed to meet its burden at the time. The remainder of this document is, it has now been approximately 20 months since the state first made its request for discovery disclosure alibi demand on May 23, 2023. As the court file reflects, by the above items, the defendant has failed to comply with the requirements of Idaho Code 19519 and ICR 12.1. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. The prosecution has repeated this many, many times. And that was directed by the February 23, 2024 order setting deadline and hearing, and as disclosed in the state's April 26, 2024 response to notice of defendant's supplemental response to state's alibi demand. The defendant proffered April 17, 2024 notice of defendant's supplemental response to state's alibi demand does not comply, that's the one where they mentioned Wawawe Park, does not comply with requirements of Idaho Code 19519 and ICR 12.1 or with specific directives of the court's February 23, 2024 order setting deadlines and hearings. Consequently, the defendant should be prohibited from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Even were the defendant to attempt to comply at this late point in time, the state is irrevocably prejudiced. It has now been over 2 years since the homicide occurred and since the defendant was charged, and it would be unrealistic at this late date to expect the state to effectively investigate and respond to any new or additional alibi-related disclosures. This is precisely the situation that caused concern for the Idaho Court of Appeals in State v. Juarez, as well as the concerns of the United States Supreme Court in Williams v. Florida, where the court noted that the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. State v. Juarez, 169, Idaho 274, 494, page, I don't know if it's page, but P.3D822, CT APP 2021, Williams v. Florida. The adversary system of trial is hardly an end in itself. It is not yet a poker game in which players enjoy an absolute right always to conceal their cards until played. We find ample room in that system, at least as far as due process is concerned, which is designed to enhance the search for truth in the criminal trial by ensuring both the defendant and the state ample opportunity to investigate certain facts crucial to the determination of guilt or innocence. For these reasons, the court should issue an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Respectfully submitted this 21st day of February 2025, William Thompson. Well, there you go, everybody. So the defense has been really just dragging their feet, waiting and waiting to get more and more information so that they can tailor their alibi to the prosecution's information. But the prosecution wants them to come forth with the information of where he was. I mean, saying that he liked to go to Wawawe Park and then to claim that he was over there that night looking at stars when apparently it was cloudy that night. There's all kinds of craziness, but we also know that recently in these hearings, Ann Taylor admitted that Kohberger was within a quarter mile of the homicide residence the night of the murders at 3:29, which is exactly the time frame that a white launcher moves into the scene and starts doing its laps, and it's missing a front license plate. So everybody, don't be fooled. Bryan Kohberger is the killer, rest assured. And hopefully I think the judge is going to rule in the favor of the prosecution on this one. It's just absurd what the defense has been doing. All right, everybody, thank you all very much for watching. I hope you liked the video. Leave me a comment in the comments section and let me know what you think. Hit that subscribe button. And as I always say, until next time, be safe out there.